Picture this. You're standing in a courtroom. The judge looks at you and asks, "Doctor, why did you treat this patient without consent?" The entire case now depends on one decision you made in the emergency room. Could you defend yourself? Every doctor should know the answer. That is part of what we're going to be doing today in medical jurisprudence. Today, we're going to cover inquest, courts and legal system, witness and summons, recording of evidence, medical ethics, and negligence and consent. An inquest is conduction of an inquiry into the cause and circumstances of a death. We have various types. We have police inquest, magistrate inquest, and coroner's inquest. Police inquest is the most common type of inquest, and it comes under section 194, whereas magistrate comes under 196. Magistrate is conducted when in cases of custodial death, where death occurs within a police station, jail, or psychiatric hospital or juvenile. The difference between police inquest and magistrate inquest: the minimum rank for a police inquest is either investigating officer or head constable. For magistrate inquest, both a judicial magistrate or executive magistrate can conduct this in cases of custodial death or rape, dowry death, and exhumation. The witnesses are called panchas, and the inquiry report is called panchanama. The power to summon a witness comes under section 195. A cognizable offense is one that can arrest without warrant, whereas a non-cognizable offense can arrest only with warrant. A magistrate inquest is superior compared to a police inquest. Of the Indian legal system. At the top, we have Supreme Court, followed by High Court, Sessions Court, Assistant Sessions Court, Chief Judicial Magistrate, First Class Magistrate, and Second Class Magistrate. The Supreme Court can give any sentence including death. High Court can give any sentence including death. Sessions Court are trial courts. Assistant Sessions Courts can give 10 years of punishment with no limit on the fine. Chief Judicial Magistrate can give 7 years of punishment with no limit on the fine. First class magistrate can give 3 years of punishment up to 50,000 in fine, and second class can give 1 year of punishment with 10,000 rupees fine. The lowest court to give death sentence is district court. The lowest court to confirm or cancel a death sentence is high court, whereas Supreme Court death sentence can be commuted by the president or the governor. Evidence and its types. An evidence is a statement or fact which is produced in court to prove or disprove something. This is information that is made to be put in front of the court by a witness. We have direct evidence, indirect evidence, oral, and documentary evidence. Direct evidence directly proves a fact, and it is considered more valid than indirect evidence. Indirect evidence does not directly prove a fact. It includes circumstantial evidence and includes hearsay evidence. Oral statement, it is considered superior evidence, and it has the ability to be cross-examined in the court, and it is taken under oath. Documentary evidence is written or recorded material presented as proof. Common versus expert witness. A common witness is any person who has perceived the fact. There is no age limit, whereas an expert witness is a witness by virtue of knowledge, skill, experience, and training. Common witness may not give their opinion, whereas expert witness can give their opinion. Common witness has first-hand knowledge, whereas expert witness does not. Summon. A summon, also called as a subpoena, it is issued under penalty for civil, criminal, or court matters. These are legal documents issued by presiding officer of the court and compels the attendance of a witness. If ignored, it is punishable. There are two types. We have subpoena ad testificandum and subpoena ducis tecum. The first one is to only give an oral statement, whereas the second one is to produce documentation. Higher court takes precedence over lower court. Criminal court takes precedence over civil court. If courts are of equal status, the one that summons first will take precedence. Conduct money. Conduct money is money paid to a witness for traveling expenses while serving the summons in civil cases. They are paid by the parties in the civil case. It is amount fixed by the court. Recording of evidence and court proceedings. We have two types of cases: criminal cases and civil cases. Criminal cases is usually in between the state and the accused, whereas civil case is between two parties. The judge can ask questions at any stage of the trial, and the judge can recall or re-examine witnesses. Steps in recording of evidence. We have taking of oath. This is compulsory. Refusal is punishable, and children under 12 years of age are exempted from taking oath. Second, we have chief or direct examination, followed by cross examination and redirect examination. False evidence under oath is punishable under section 227. Fabrication of evidence is punishable under section 228 and both under 229. Cross and redirect examination. Direct examination is done by the same side lawyer. Cross examination is done by the opposite side lawyer, and redirect is done by the same side lawyer. The direct examination of the prosecution witness is done by the prosecution's own lawyer. It is cross-examined by the defense lawyer and redirect examined by the prosecution's lawyer. In direct examination, the defense witness is examined by the defense lawyer. It cross-examined by the prosecution lawyer and redirect examined by the defense lawyer. Leading questions are not permitted in direct. They are permitted in cross-examination and they are not permitted again in redirect examination. Difference between dying declaration and dying deposition. Dying declaration can be recorded by anyone, whereas dying deposition is recorded only by a magistrate and it is considered superior to dying declaration. Oath is not required in dying declaration wherever it is required in deposition. The presence of accused or accused lawyer is not necessary in dying declaration, whereas the presence of the defense lawyer is necessary in dying deposition. If the patient dies, dying declaration is valid. Dying deposition is also valid if the patient dies, whereas if the patient survives, dying declaration is considered invalid, but dying deposition is still considered valid. It is Dying declaration is used in India, where deposition is not used in India. Medical ethics are compulsory and punishable. These are guiding moral principles in between the doctor to doctor relationship, doctor patient relationship, and doctor state relationship. Practicing under the influence is a violation of medical ethics and not just etiquette. Whereas medical etiquette is not compulsory, it deals with the relationship between colleagues, and violation leads to warning and not legal punishment. Professional misconduct and disciplinary action. Infamous or unethical conduct. Examples are addiction, alcohol, adultery, issuing false certificates, accepting gifts from a pharmacy, conducting criminal abortion, association with unqualified person, repeated or inappropriate advertisements, covering or assisting or employing an unqualified person, dichotomy, which is fee splitting. Euthanasia active is a crime, whereas passive is permitted in India. International declarations. Declaration in Venice is for terminal illness. Lisbon is for patient rights. Malta is the hunger strike. Washington is biological weapon. Tokyo is torture. Helsinki human experimentation. Geneva is medical ethics. Oslo is therapeutic abortion. And Sydney is death declaration. Basic ethical principles. We have autonomy, justice, beneficence, and non-maleficence. Autonomy is the right of the patient to choose their own treatment. Justice refers to treatment of all patients the same without any discrimination. Beneficence is acting for the best benefit of the patient, and non-maleficence refers to doing no harm. Medical negligence and factors comprising negligence. Medical negligence is omission of a right act or commission of a wrong act. First, we have dereliction of duty, which is direct causation. The doctor had a duty and failed to fulfill it, leading to directly causing harm. Deficiency in duty, where the absence of reasonable skill or care or willful negligence in performing the duty. Damage, the harm suffered can be monetary, pain, disability, or death. Types of negligence. We have civil and criminal negligence. Civil negligence is conducted in civil or consumer court, whereas criminal is in criminal court. The parties involved are patient versus doctor in civil negligence and state versus doctor in criminal negligence. The burden of proof lies on the patient. The burden of proof in criminal lies on the prosecution. Punishment may be monetary compensation, whereas in criminal, the punishment may be jail and fine. Doctrines of negligence. Res ipsa loquitur means the facts speak for themselves. This applies to grossly negligent acts by doctor. The burden of proof of innocence lies on the doctor, and no expert opinion is needed to prove it. Responded superior, meaning let the master answer. This means that the superior is liable for the negligent act of a third party. It is also called as vicarious liability, only applicable in civil cases against negligence. 1. No duty existed towards the patient. 2. Duty was given as per standard protocol. 3. It was a therapeutic misadventure leading to accidental damage. 4. Contributory negligence by the patient. This is the patient contributed to the negligence. 5. Novus actus interveniens. This is a new or unrelated intervening act led to the damage. 6. Res indicator. This is a limitation period. For civil cases, it is within 2 years of knowing, whereas there is no time limit for criminal cases. 7. Res judicata. That is things already decided. The patient cannot refile if unsatisfied and can only appeal. Consent and the minimum age. For medical termination of pregnancy, the minimum age of consent is more than 18 years. If the person is less than 18 years or is mentally ill, we need guardian's consent. For major procedure, the age of consent is more than 18 years. For physical examination, more than 12 years. If the person is under the influence, insane or intoxicated, consent is invalid. Medical exam of the accused, consent is not mandatory. Whatever medical examination of a rape victim, consent is mandatory. If the child is less than 12 years in a residential school, the guardian may give consent.